Check out award-winning Johnson & Boon Solicitors' unique product, Legal Guard. Ideal for businesses and individuals, Legal Guard ensures you get the legal help you need when you need it. Packages start from just £24 a month and include free expert advice, access to a library of legal documents, as well as exclusive discounts on a range of services. For more information, visit johnsonandboon.co.uk/legalguard and quote the code THECHESH. You're listening to Johnson & Boon Solicitors podcast exclusively on the Pod Station.
Welcome everyone to another episode of the Johnson & Boon podcast. My name's Mark, I am the host. Joining me again this week is the wonderful, the irrepressible Rob Boon of Johnson & Boon fame. How are we doing, Rob?
Mark, good to see you. How are you?
I'm not too bad at all, I can't complain. Still stuck in my house during lockdown 3.0 or 6.0. I've lost track, I think, now.
Yeah, I think we've all lost count now.
Rob, before we get stuck into the topic of today, do you want to just quickly explain why we do these podcasts? So if people are listening for the first time, they might understand a bit more before I run through where they can catch it all.
Yeah, so what we do each week is we discuss a different area of law, or we drill down on a specific piece of legislation that might have changed. We might speak about something topical, and the idea is just to give people some information, a flavour of the overall subject, and then if they need any help, then they can contact us. If not, it might be one of those subjects that they can try themselves.
So if that is something that might be of use to you, and certainly if you enjoyed this particular episode, then if you want to catch some of the previous ones, there are 34 other episodes to check out at this point in time. If you go to johnsonandboon.co.uk, you will find a podcast tab where you will find all of the previous shows, and in each of those episodes you will also find links to the major podcast platforms where you can also get them. So if you go to, I don't know, say Apple or Google Podcasts, you will find the show. If you type in Johnson & Boon, you can subscribe, and then when the latest episode drops, it will automatically download onto the device that you use. It's as simple as that. You can also download the Johnson & Boon mobile app, which again has a podcast tab on there, which allows you to listen to the whole show. Why would you want to do that? Well, there's a whole host of other features on that app, isn't there, Rob?
Yeah, there certainly is. So you can access all of our articles. You can have a look at the different services that we do. If you're one of our Legal Guard members, then you can log into the Legal Guard membership area. If you want to book an appointment with any of the team, then there's an appointment tab where you can actually see our diaries live and drop an appointment in. And it also tells you which member of the team would be best for you for any given section. So it's a really useful thing. And as you say, it's free in terms of downloading it.
So there you go. Why would you not? Indeed. Right, so Rob, what's the topic that we're going to be covering today?
So today we're going to talk about and review the very longly worded, the electrical safety standards in private rented sector regulations 2020, which all sounds very complicated, but it basically governs the obligations on landlords, and that's private landlords, in relation to electrical safety. So these were brought in last year in April, and so far they've applied to all tenancies that were new as of the 1st of July 2020. Now that all changes in April of this year, and as that date's fast approaching, we thought it'd be a good time to bring these regulations to everyone's attention who isn't maybe aware of them so far.
I should actually pick you up on a error there, Rob. When you were reading the snappy title, you missed out England in brackets, which was an extra word that goes in there. Obviously, the people who wrote this legislation weren't necessarily in for the snappy abbreviations, were they?
No. I thought I'd spare you for the brackets as I went through that, but you're absolutely right. For those who want the full title, there is an England in brackets in there as well.
So, what was the law before this snappy little bit of legislation came into play?
So before April 2020, the mandatory electrical inspections, which focus in this legislation, were only legally required in houses of multiple occupation. So for other tenancies, it was recommended that an electrical installation condition report be carried out every 5 years, but that was more of a recommendation than an actual legal requirement. So whilst many landlords followed that, many didn't. And the new regulations aim to bring all that in line and make sure that all tenancies are covered, and all tenants are kept safe.
Is there a particular reason why they felt the need to bring in this regulation?
Over the last few years, anybody who's familiar with the private rented sector and the obligations on landlords will be aware that everything has been being brought into line. So there's a huge amount of focus. The Tenant Fees Act came in terms of regulating lots of stuff. There's been recent cases in terms of what is and isn't okay in relation to the service of gas safety certificates. There's been a lot of focus on tenancy deposit matters, and it's a really highly regulated area. One of the focuses of everything that has changed has been trying to make the rental sector as a whole better for tenants. And this is just another one of those things that, whilst gas was previously, highly regulated, electric wasn't. But obviously it's very dangerous if properties have poor electrics. So the idea really was just to make this more mandatory. And whilst it's onerous on landlords, because it relates to safety, it's seen as needed.
So when did these regulations come into force for the first time?
So the regulations themselves, they came in April, but they only applied to all new tenancies, and that is new tenancies granted after the 1st of July 2020. All existing tenancies aren't affected by this until April of this year. And as I said at the start, that's one of the reasons why we're doing this today, because there's lots of people that still aren't aware of what's required.
So if there's a landlord listening to this now, or in fact a tenant who is listening to this now, and they're thinking, crikey, what's this going to entail? What is it that private landlords are needed to do to comply with these new regulations?
So all private landlords are required to do numerous things. So that is ensure that the electrical safety standards are met during a period when the residential premises are occupied by a tenant. And we'll talk later on about what is and isn't excluded, but generally that's under the terms of an AST. They have to ensure electrical installations in the residential premises are inspected and tested at regular intervals, and that's got to be done by a qualified person. And qualified person is defined in the Act as you'd expect somebody with the relevant expertise to do so. In terms of other obligations, they have to ensure that the first inspection and testing is carried out before the new tenancy commences, and that is for all tenancies after the 1st of July 2020 at the moment. They also have to ensure that the first inspection was carried out before the tenants obviously moved in, and if there are any issues before they move in, then they need to be rectified. Once the inspection and the testing has taken place, they'll get a report from a qualified person, and as I said before, that is within the definition of the Act. That person will identify and will give a report as to any problems. They'll also identify when the next report needs to be done. So then with that report, the landlord has to give a tenant a copy of it within 28 days of the inspection. They also have to provide a copy to the local authority, and they also have to retain a copy, because next time the report gets done, the next relevant person who performs the next assessment will need to see one. So it is fairly onerous, but it is very similar to the processes that would be followed for things like gas safety, where they have to get a report, has to be from a proper person, and then they have to give a copy to the tenant. The difference here, obviously, is the it seems like it will be a more detailed report, and they have to retain a copy for the next person.
So to put it in its simplest form for anyone who's struggling to keep up with those dates, the rough rule of thumb is by the 1st of April, if you have a tenant in a property, there needs to be an inspection. Some of them, which might have happened after July 2020, should have been done before people moved in. But simplifying it slightly, if you haven't got one, you need to get one.
Absolutely. The difficulty is going to be that obviously at the moment, we speak during the term of another lockdown, as we mentioned at the start. These reports require somebody to actually attend the property, and at this moment in time, that might either be very, very difficult or certainly slow. So landlords need to, if they need one of these reports, get it booked in nice and early, because it may not just be a case of getting the report. It might be the steps that they need to take afterwards in terms of rectifying any issues.
If a landlord can get an electrician to go to the property and they do an inspection all as well, that's fine. The report comes through and they can disclose it. What happens if the report actually uncovers some unsafe electrics?
So if the report indicates that the property is not electrically safe, the landlord has to ensure that the recommended work that's detailed within the report is carried out. And again, that has to be carried out by a qualified person. They can't do it themselves. They can't get a mate to do it who's, unqualified. The work has to be carried out within 28 days or within a period specified in the report, if that's sooner. And obviously that's going to depend upon the significance of the work and how dangerous it actually is. The landlord then has to obtain written confirmation from the qualified person who completes the work that the work has been done and it meets the safety standards that it didn't previously. And then they'll give a copy of that to the tenant and to the local authorities, along with a copy of the original report.
And what happens if they don't comply with that?
This is the scary part. If the local authority believe that a landlord is in breach of their duties under the Act, they'll serve them a remedial notice, and they have to then take immediate action. If they think, and it's beyond reasonable doubt, so it's in line with the criminal threshold. But if they believe in line with that threshold that a landlord has breached their duties, they can also fine them up to £30,000.
Okay, so it's not a cheap thing to overlook.
No, it's very serious. I mean, electric is obviously one of those things that can't be toyed with. And the whole point of these and the whole point of the high fine is to make sure that people pay attention and that these regs are actually followed.
Obviously, housing authorities will take action if they know that there is a problem, but how do they know that there is a problem if they don't know that there is a problem? Was it the FBI guy who said it's the knowing knows and who knows and whatever it was. If a landlord isn't a registered landlord or that they don't know that there's a tenant in a property, one assumes that there's going to be they're not going to be bothering with these sorts of inspections. So how will they know to then take the action?
It's a good question. It's similar in many of these areas where, if the local authority don't know something's going on or they don't know a property is let, then it can slip through the net. There is really good mechanisms in place now, though. I mean, in lots of places around England, landlords have to be registered. There'll be lots of tenants who are claiming some sort of housing benefits, so obviously they'll be on the radar. But if a tenant knows that the electrics are substandard, if they're having problems, this legislation and these regulations will be in the media as it rolls out. And one of the first things they'll do is they'll contact the local authority in order to take action for them in terms of remediating it.
Yeah, sorry, to go back, it was there are known knowns and there are things we know that we know, and so on and so forth. I think the long and short of it is that hopefully there's going to be many other things that capture them, whether it be through secondary fail-safes, I guess.
Yeah, absolutely. It's very unlikely that long-term landlords will be able to avoid this.
Because there have been quite a few additional regulations throughout the course of the last few years to try and tighten this sector, isn't it? To avoid rogue landlords from being able to operate.
It has. I mean, there's many letting agents that we speak to, because we act for lots of letting agents, the same as we act for many tenants on different types of matters. And letting agents over the last 4 or 5 years have really struggled in terms of keeping up with how quickly legislation has changed. I think we've done a couple of shows in the last 12 months in which we've spoke about lots of different changes, right down to the simple thing of how long is needed for things like Section 21 notices. I think that's changed about 3 times in the last year. So it's a very movable area of law, and it is all going in one direction, and that is to make sure that the tenant lives in a safe property, they're dealt with fairly, and it's to avoid the whole sort of rogue landlord thing, if you like.
You mentioned right at the outset that there were exclusions to this legislation. So how is it that a tenancy might find itself not falling under these new regulations?
Yeah, so most tenancies are covered by these regulations, and that includes HMOs, so houses of multiple occupancy. There are a few types of tenancies, though, that are excluded, and you'll find that these are also the same types of tenancies that are excluded from things such as the deposit protection legislation. If there's a tenancy where the landlord actually lives with the tenant, or if they're a member of their own family, say in a house or a lodger, that's excluded. If the tenancy is with a landlord who is a provider of social housing, that's excluded. If there's a property which is a long lease, so something which would be 7 years or more, that's excluded. Student accommodation is excluded. And then all the usual things that you would debate whether they're actually tenancies are excluded. So you're talking about hostels, refuges, care homes, hospices, hospitals, any other type of healthcare building of that type that you might stay in for a while. All of them are excluded. But with most of them, there is other types of legislation that deal with health and safety anyway. So these are targeted specifically at the private rented sector, and specifically at your everyday landlord who rents, a couple of properties to personal individuals.
A couple of questions there. With the student accommodation, that's quite an interesting one to be in the exclusion. Is there any particular reason? Because quite often students do rent from private landlords, and I suppose sometimes when you're in these big student accommodation blocks, the properties that they're renting are actually from private leaseholders. So would that fall in, or are we talking about accommodation that's owned by a university, sort of the halls of residence?
Yeah, it'll be interesting to see how it plays out. I think it more relates to halls of residence. So if you have an AST, an assured short hold tenancy agreement, then you fall under the boundaries of this. So just because you happen to be a student, I don't think that would give the landlord a way out of saying that they don't have to comply with this. It comes down to what is your tenancy more than what is your purpose. So I think it more relates to things like halls of residence within university campuses and that type of thing. And of course, that's because they're regulated themselves anyway in lots of different ways.
I suppose that makes sense, because I guess I was going to say I can't really remember what I signed when I moved into halls of residence 100 million years ago. I'm assuming it must have been an AST, an assured short hold tenancy agreement, but I can't remember. So it'd be if there are other regulations perhaps which capture them in those situations, it explains it, doesn't it?
Yeah, and you will find, I mean, this is something, it's new legislation, and, we haven't quite seen how it plays out yet. The idea is, as I say, to bring in line the majority of the tenancies, and the majority of the tenancies in England and Wales are assured short-hold tenancy agreements, or their properties that relate to HMOs, and they are really where the risk is seen. So it's anticipated that if you're staying in a university campus, the university themselves will make sure that the building is adequate. Now, whether on the ground that's actually always the case, is a matter of opinion, but it's aimed at making sure that safety is a feature. The gas safety regulations do that from a gas point of view, and this is intended to a certain extent to mirror that and make sure that the electrical side has to be looked after as well.
There's a couple of other interesting ones. HMOs, I mean, we've explained their houses of multiple occupancy, but perhaps that explanation isn't something that people understand. Is there a sort of a more obvious way of describing what a HMO actually is, so people might understand if they are living in one?
Yeah, if we give an example rather than examine the law on it. So if you think sometimes you get these big old Victorian houses that once were a 5, 6, 7, 8 bedroom, semi-mansion, if you like, and over time it just doesn't make sense for people to occupy them as a family. So what you'll have is you'll have multiple adults that wouldn't necessarily live together, all living together under one roof, and they might have sections that are excluded, they might have sections that they share, but they're in multiple occupancy of the property. So it's multiple families living in a single property. Different to flats, of course. If it's divided off into flats, then that's entirely different again. But most people, they're very common down in London and in the south, in that area, because there's lots of big properties, but rents are very expensive, and the way in which they deal with that is to divide them up and have multiple occupancy people in there. The difficulty with that is, for a long time, those properties were fairly sketchy in the way they'd been set out. They weren't maybe necessarily right in relation to fire regulations and fire escapes, and people were in these properties that were expensive to live in. They were dividing it more and more and more, so you'd find that there was an unsafe number of people. There's lots of regulations now in place. It's a hugely regulated area in terms of what those properties have to meet in order to be legal, and this is just something that supplements that. So this is something that covers the electrical side.
If a tenant and the landlord live in the same property, I assume the exclusion is on the basis that a landlord won't want to live in a dangerous property with electrical faults. But of course, if they don't know or care or don't have the finances to do that, one assumes it can be left in the situation where the tenant will be exposed to the electrical risks that this sort of regulation is there to remove.
It's a good point. It's an interesting one, though, because obviously when the landlord lives in the property, and it's almost like a lodger situation, there are other pieces of legislation that apply to tenants and landlords that don't apply. And a classic example is the requirement to protect the deposit. You or I probably wouldn't have one of these reports done in our house, but nevertheless, we would expect that our electrics would be safe, and we do everything we can because we're living there to make sure that they were safe. So I think the idea is to not, it's an informal relationship, or it's a more informal relationship when you have a lodger and you're sharing the accommodation, and that lodger generally has much less by way of rights, certainly in terms of the stage that they're being evicted, than what they'd have for an AST. And as a result, because they're sharing the property, it's normally much cheaper, or they already have some sort of relationship with the landlord. So I can see, some people may say that it sounds a bit strange, but it is something that's mirrored in other legislation that affects tenants. And I think if people are uncomfortable with that, then it's a case of stay away from that arrangement and have a proper AST separately with your own flat or your own house, wherever it might be.
And you mentioned, of course, about the financial penalties for doing it. Might there be a liability on a criminal side of things if a tenant were to suffer some, like an electric shock, as it were, and God forbid end up dying? Is there the likes of corporate manslaughter?
It's always possible. I think, the majority of these matters are going to be dealt with by way of a fine, and that is not the tenant that brings that action. I think if somebody is injured as a result of being electrocuted or something along those lines, it's more likely that they will bring a civil action for damages off a result of that, similar to a personal injury claim. And there might be other things in there. So if the property wasn't fit for them to live in, then there's lots of claims that are brought under Section 11. You may have heard the phrase Section 11, and that all relates to the fitness of the property in disrepair, etc. So I think a lot of people will end up in this situation off the back of those matters that then housing and local authorities become aware of. Really extreme cases, then you might find that there's a criminal prosecution, but I think most of them would fall into the first two categories.
So if you are a landlord, or I suppose it's probably more relevant for landlords, this sort of a change, and you need to get some advice on what you need to be doing, and perhaps double checking that they've crossed the T's and dotted the I's for some of the other regulations which we've perhaps mentioned as an aside during the course of this episode, how can they get in touch with the Johnson & Boon team?
So the best thing to do is to book a consultation with one of our landlord and tenant team, and that includes myself and a couple of the other guys. They can either message us via the website, so they can go on johnsonandboon.co.uk, and there's a message tab. As we said before, they can download our app and book an appointment straight into one of our diaries. They can call our office on 0151 637 2034, or they can look us up on any of the major social media platforms. They could always just drop us an email as well to info@johnsonandboon.co.uk. So
loads of ways of getting in touch, guys. Hopefully that's been of interest. If it has, do us a favour, if you could go onto the podcast platform you use and just give us a quick review, that'd be fantastic. It just lets the show be seen by more people, and hopefully we can help someone else, as I hope we've helped you today. Give us a follow on social media, Johnson Boon, as Rob has said. We're on Facebook, LinkedIn, Instagram and Twitter. You can also actually listen to this whole show on YouTube now, so if you just go and give us a follow on that, as you say, if you want to drop a message or you just want to throw a comment on there, then please feel free to do so, and we'll happily answer those questions in future episodes as well. Rob, thank you very much for your expertise today. I think people who this applies to will probably have found it extremely useful.
No problem at all. Thanks, Mark.
We'll catch you next time, guys. Thanks very much for listening. Bye now.
Get social at Johnson & Boon on Instagram, Facebook and Twitter.